This next matter is State versus Haughwout. Each side will have 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. Since we're on this virtual platform, how we will handle questions from the justice, they will either raise their physical hand or their virtual hand. When you get to your next logical stop point, please stop your argument so that I may call on the justice so they may ask the question. With that, is counsel for the appellant ready to proceed?
Yes, Your Honor.
Please identify yourself for the record and let me know whether you wish to have any time for rebuttal.
Thank you, Your Honor. Good morning, and may it please the court. I'm Jennifer Bourne from the Office of the Chief Public Defender for Mr. Haughwout. I would like to reserve 7 minutes of my time for rebuttal.
Thank you, counsel. Senior Associate Justice McDonald will be keeping time for us. He'll let you know when there's 5 minutes, 3 minutes, and your time is up in your main argument. Whenever you're ready to proceed.
Thank you. I'd like to focus today primarily on the first and third issues in the brief, the denial of the motion to suppress for the July 19th event and the failure to instruct on proximate cause for assault on an officer for the July 22nd event. And I'll just say at the outset, that this is a case where there is video and audio recordings of both events, and it does become important to the resolution of the issues to view those. This isn't a case where we can necessarily rely on or assume that the jury relied on testimony in this case that is inconsistent with what's made plain in those recordings. So beginning with the first issue that the court denied the motion to suppress, that's primarily for two reasons. And the first is that there wasn't reasonable and articulable suspicion for the officer to detain Mr. Haughwout in the parking lot of the Clinton Library. And that means that any and all evidence that was derived from the stop, including the officer's observation of the defendant's conduct, must be suppressed. And the second reason is that the Fourth Amendment doesn't permit the state to prosecute and convict a defendant for failing to comply with an illegal Terry stop. So the first issue on the reasonable and articulable suspicion, I'll say, there is some dispute in the briefs and in the record over when the detention actually occurred. And I will say that my position is that that doesn't matter to the outcome, because there was never a point at which the officer had reasonable and articulable suspicion to suspect Mr. Haughwout of criminal activity in that parking lot. Our position, though, is that he was detained at the outset of the encounter when the police officer pulled into the parking lot and motioned for Mr. Haughwout to come over with his lights on. And I see there's a question.
Thank you, counsel. There's a question from Justice Doria.
And really, this is just more by way of framing. I just want to point out to you, counsel, many of us, if not most of us, have seen the video. We can do that easily these days. So it would be helpful as you frame your argument to sort of refer to where in the video you're talking about specifically, because I know it's challenging to do it otherwise. So it's just more of a statement.
Okay, thank you, Your Honor. I will do that. So at the outset, when the officer pulls into the parking lot and motions for Mr. Haughwout to approach, he does that, and he tells him why he's there, which is he's using the Wi-Fi, and that it's not disputed as something that people regularly do in this parking lot. And the officer then instructs him to stay there, and I'll be right with you. And then the officer turns his cruiser around. On the video, you can hear Mr. Haughwout asking, "Do you suspect me of a crime? Do you suspect me of a crime?" I see that there's a question.
Counsel, Justice Khan is just getting in the queue. And so what I'd like for you to do is please continue your response, and then I'll call on Justice Khan when you're through with your response.
Okay. So at that point, the officer doesn't have any reason to suspect any criminal activity in the parking lot. Someone being in that parking lot is not any reason to suspect that there's a crime occurring. There is some testimony about a prior burglary that had occurred at the library some 7 or 8 years prior to this incident, which also doesn't really add anything to the story here. I mean, it's hard to believe that there's any area, particularly near a commercial area and stores, where there hasn't been a crime in the last 7 to 10 years. And that certainly doesn't add anything to the officer's level of suspicion. And so, I mean, I guess now is a good stopping point.
Thank you, counsel. Justice Khan.
Thank you, Chief. Thank you, Chief. I hope you can hear me, Counsel. For some reason, the cursor takes longer to unmute and mute. So my question is this, and I understand, I have two questions. So the first question deals with this issue that you're covering now, which is reasonable articulable suspicion. I understood that the police were relying on three additional factors. One is that the location he was sitting in outside of his car in the back rear of the lot is not known to be the best location to access the free Wi-Fi. Two, that it's a darkened area of the lot where police have seen people use that area to sort of stage crimes, apparently at some strip mall or area nearby. And third, that the gate, well, four things. The gate was open to the back of the library where it had been previously broken in. And fourth, that your client's conduct upon seeing the police was to immediately run to his car and start to drive away. Why wouldn't all of that conduct support a conclusion of reasonable articulable suspicion? And then I have one more question after that.
Okay, thank you. So my position would be that even if we assumed all of those facts were true, that he got in his car to leave the area when he saw the police officer, that he was sitting outside in an area where the police officer surmised the Wi-Fi signal would not have been that strong, that the gate was open to the patio area immediately next to the library, that still would not be reasonable and articulable suspicion that he's committing any crime there, particularly given his explanation of what he was doing there, that I was sitting at a picnic table using the Wi-Fi and I'm leaving because the bugs were eating me, that there's not anything that doesn't add up or that would give rise to think that there's a crime being committed. But I would note, and I go into some detail about this in the reply brief, that there are problems with those factual premises. I mean, we can see from the video that the defendant doesn't rush getting in his car and leaving when the officer's pulling in, that you can see that the video starts and there's several seconds of the defendant getting in his car, setting up the camera before he even pulls out of the parking space. And then he encounters the officer on his way out. And we're several seconds, if not close to a minute into the video when he encounters the officer.
But even assume he didn't run, okay, just a quick follow-up on this. Can't the police, because of the late hour of the night, and the other, aren't the police entitled to at least check before they let him go? Just check to make sure nothing's broken, he's okay. Isn't that a reasonable thing for the police to do? And then I do have another question. And I see others have their hands up, so I don't want to take too much time. But can't the police just check? I mean, are they supposed to say, okay, 100%, you're right, and not even check why the gate is open?
Well, I do think the police officer can patrol the area, but whether the officer can stop a citizen and detain them, the officer needs reasonable and articulable suspicion that there's a crime being committed. And so I appreciate that the officer could have circled through the lot and done a patrol, but the officer can't detain Mr. Haughwout without that level of suspicion.
Okay, so I understand your argument on that. I want to get to my second question because I see other hands are up. Let's assume we were to agree with you. No reasonable articulable suspicion, no basis to charge him for the July 19th. The avenue for him would be a motion to dismiss, a motion to suppress. Even if that arrest, let's say, had no legal basis, and so there's no basis to support the first warrant, why would that excuse criminal conduct in response to that warrant? In other words, when he turns himself in at 8 o'clock on July 22nd, even if he feels he has a valid argument to get that warrant thrown out, to get the case thrown out, that doesn't give someone the right to, assuming there's evidence of the additional crimes, that wouldn't excuse a subsequent conduct, would it? And particularly when the sentence in this case is all driven by the July 22nd incident.
I understand Your Honor's question, and I think Your Honor is correct. And we are claiming separate legal issues and other problems with the July 22nd convictions, but not that the events on July 22nd needed to be suppressed because of the illegality on July 19th.
Anything further, Justice Khan?
Yes.
You're muted,
I'm sorry,
Your
I misunderstood. Justice Khan, you're muted.
I understand, Chief. The button takes a long time. I apologize. It shows up as being off and then it goes back on. So you concede that the two incidents are separate and can be assessed separately in terms of the evidence to support the July 19th versus the July 22nd. Do you agree with that?
Yes.
Okay, thank you. I am done, Chief. Thank you so much.
Thank you very much, Justice Khan. Excuse me. Justice Doria.
Thank you. What do we know, if anything, about your clients taping these events? Which is, there's nothing wrong with that. But do I read your brief? Tell me if I've read your brief incorrectly to say that when he's behind the library, that he doesn't know that the officer is there while he's headed to his car, and so he couldn't have been hurrying up? Or are you just suggesting that he wasn't hurrying up? My point being, is he taping all police interactions, and so he knew that he was going to get pulled over and questioned? What do we know about that?
There's not evidence to suggest that Mr. Haughwout saw the police officer before he pulled out of the space and saw him toward the driveway. So I can't really say on this record.
So we don't know if he, whenever he drives, he just, as soon as he drives, starts his camera going, even if there's nobody he's going to interact with, he may just do that. But it wouldn't be a fair inference for us or the trial court to say, okay, he did see the officer, he knows he's coming, and he's gonna tape it.
I don't believe that would be a fair inference on this record, no. And no, there's not evidence in the record about his driving habits and his recording habits outside of this incident.
Okay, thanks. That's all I got.
Justice Ecker. My mistake, Justice McDonald.
Yep.
Then Justice Ecker.
Thanks, Chief. Counsel, I have a couple of record questions I just want to understand. I understand Officer Santiago knew the defendant from previous interactions. Did the officer know that the defendant was autistic?
There's not evidence in the record of that.
Okay. And was there any evidence in the record about the level or extent of the defendant's autism? I saw it was on the spectrum, but was it any more defined than that?
There is some information at sentencing hearing about someone who did an evaluation of Mr. Haughwout. Not
trial.
Correct.
Okay. And what was I understand that Officer Santiago said that he knew that the Wi-Fi signal was stronger at a different area. Is that something, was there any evidence in this trial that that was generally known in the community where the strongest Wi-Fi signal was?
No, there's no evidence about that. And Officer Santiago did acknowledge that he hadn't ever tried to use the Wi-Fi before or after this incident in the location where the defendant was. Okay, and my final question on the record is there's a lot of, two questions, I'll make them quick. That this was an unlit corner of the parking lot. Is there evidence that the rest of the parking lot was well lit
at 9 o'clock, and this was the only dark corner of the parking lot?
No, there's no evidence to that effect. There's no evidence really of the lighting in the parking lot other than some photos where you can see some lamps in the parking lot. But this was next to the building. So when you look at the photos, you can see that the patio area is immediately to the right of the library if you're facing the library, and then the parking area where Mr. Haughwout was near the patio area, in front of the patio area.
My final record question is, there's statements in the briefs that the defendant moved quickly to leave the parking lot. Who testified that he moved quickly?
I believe that that's a characterization of counsel. I would have to look to see if Santiago characterized it that way. Officer Santiago does say that when he was pulling in, the defendant got in the vehicle to leave. He does say that.
But he didn't characterize it as moving rapidly or running to get into the car or anything like that?
I don't remember him characterizing it that way.
Okay, thank you.
Justice Ecker. You're muted, Justice Ecker.
Counsel, I had some questions that I don't know if they're well-founded or not, so you'll tell me if they're not. I had difficulty reading this record and not thinking that this was planned by your client in some respect. I don't mean that necessarily as in a negative way. I mean, you could view it as a cynical attempt to create a problem where none existed, or even to create the predicate for a lawsuit or something. You could also view it as a form of civil disobedience, planned civil disobedience. I say that because, he looked up the law beforehand. He was finding out sort of Terry stop related law. It all seems a little staged to me, at least a little. And, he used legal terms, really almost insistently. Some obvious ones, sort of Terry related. I also caught a flavor of Florida against Royer in there when he said, "I'll be on my way," which seems to be exactly the language in that case that is used by the court. How do you respond to that point? I don't know which way it cuts, whether it's relevant or anything other than that to me, it's sort of the elephant in the room.
Thank you for the question. I think, and that really was a part of the state's closing argument at the trial, right? I mean, that was their view of the evidence. There is evidence of, and mainly in the suppression hearing, not so much before the jury because a lot of it occurred when Mr. Haughwout was a juvenile. But there is a history between this police department and Mr. Haughwout. And he is very interested in his legal rights, and the record does bear that out, that he studied it and he wanted to know what his rights were with these encounters with the police officers, and that he had prior negative encounters with this police department, but then pulling him over, and his perception was unjustly harassing him. So I understand Your Honor's question, and that's obviously the state's view of the evidence. It's not our view of the evidence, in that him knowing his rights and wanting to know his rights in preparation of future encounters with this police department isn't the same thing as, that this is some staged event that he's hiding out waiting for the police to, which I think is a little bit speculative on this record, to say that.
Sure, and I'm not saying, just to interrupt, it is a little speculative, and I'm not saying it's true. I'm also not saying that even if it were planned, that means that the police were justified in how they responded. Maybe they were, and I'm not suggesting either way, but I don't think necessarily the fact that it was planned cuts against you legally, but maybe it does. Anyway, thank you for answering my question.
Thank you.
Please continue, counsel.
Thank you. So moving to the issue of whether the Fourth Amendment allows prosecution if there's no reasonable and articulable suspicion, and and which I think is briefed, and so I won't harp on it long, but I do want to make the point that, when this court decided Oquendo, State versus Oquendo, and provided more protection to our state residents, in terms of what constitutes a seizure. It was contemplated that in Connecticut, when an officer yells stop or there's a show of authority, you are seized, and the officer must then justify the stop. And under the federal constitution, that's not true, right? The officer yells stop, and if you run and you throw drugs away and the officer sees you do that while you're running away, the officer can also use the fact that I observed you throw drugs away to justify the stop. And the exclusionary rule won't preclude the admission of those drugs. And it doesn't make any sense, under Okendo to have a rule where you can be prosecuted for not remaining present during an invalid Terry stop. It's sort of turning the whole thing on its head, where if it becomes interfering, you lose the right to challenge the officer's decision to tell you to stop to begin with, because now you've committed another crime.
Justice Doria.
And when you say that, including about Okendo, I take it you don't mean that when he yells stop, that if asked what are your grounds, that the officer has to answer that question. That is to say, it's still an objective question. If he has articulable suspicion, or does he have to tell somebody what the grounds are?
I think whether it has been important to this court, like in Alloy and in Silva, the extent to which, when you're talking about the sufficiency of the evidence for interfering or what constitutes interfering, the extent to which it was clear to the person whether the person knew that the person was an officer, what the officer's purpose was, and then how you responded to that. So, it is relevant. I wouldn't say that there's an obligation that the officer answer the question, but it does create problems if the officer's not upfront about.
Yeah, that's the challenge I guess we'll have in sort of figuring out if how to apply this rule is if he's got to answer the questions, your client takes the chance that when he takes off, and maybe he reasonably thinks that he clearly said that you don't have any reasonable grounds to keep me, so I'm taking off. You haven't answered my question to my satisfaction. That can't be the rule. But so I don't know if you have any help for us in fashioning how we would, if we always litigate these things after the fact, obviously, and it, sometimes the state would backfill with the facts and say, well, we could have relied on this or that. But that night, what do we do? What do we do? Is he free to leave?
I understand Your Honor's question. I think, though, it has to be the rule, because otherwise you can't.
Has to be the rule that he has to. It has to be to your client's satisfaction. He reasonably doesn't think there's reason to keep him.
No, I'm sorry. I meant that after the fact, and understanding that the client in the situation assumes the risk, right? If you walk away and it's a valid Terry stop, or if you fail to comply with the officer's request and it's valid, depending on the circumstances, this court can uphold an interfering conviction. But where it's an invalid stop, to allow officers to stop people without any basis and then search for an interfering charge, or the second somebody doesn't comply with something, now they're guilty of a crime, is a problem under the Fourth Amendment. And I see my time has expired.
I'm all set, Chief, if you've got.
Thank you. I do have one quick question. I also had an opportunity to look at the videos and listen to the audio, and it was a rather fluid situation, and the officers were saying things at different times, and Mr. Haughwout was also doing that. And I can't remember exactly when it occurred, but there was an exchange between Mr. Haughwout and one of the officers, and he said, basically, I was doing an investigatory stop, and I think he said two different things, or it might have been two officers. One is I wanted to see if he had damaged something back there, and the other one, or maybe the same officer, said I wanted to see if he was all right. And so Mr. Haughwout's been seized. Let's take that for granted. But you have these two explanations for it. Why aren't either of those explanations valid explanations for the stop?
Well, in terms of why aren't they why isn't that reasonable and articulable suspicion is a different question than was it a sufficient explanation to Mr. Haughwout? And on the second point, I would just note that explanation wasn't given until the last stop on Route 81.
Yeah,
after
I don't know the timeline.
So that's after some of the conduct that the state claims constitutes interfering and failure to obey the officer's signal, because he's already at the last stop on Route 81 when the officer finally tells him something and he gets conflicting answers, right? They were scrambling a little bit for what the purpose really was. And then in terms of reasonable and articulable suspicion, I mean, no, I don't think just because there's a car in a parking lot, the assumption is there could have been something wrong with you or a medical emergency, so I have the right to stop you.
There's not just a car in the parking lot, there's a car in the parking lot at night in some state of darkness.
But that would justify all manner of stops. And in similar situations, or even when there's additional indicia of nervousness or other things, this court has held that presence in a high crime area isn't enough on its own, that, you know, being in a parking lot where we know crimes have been committed is not enough on its own. And so that can't be it.
Thank you.
Thank you.
You have your remaining time. Mr. Seguro.
Good morning, Your Honors. May it please the court. Timothy Seguro, Assistant State's Attorney. I represent the state in this matter. Kind of as a housekeeping point of clarification, let me first say that for purposes of the July 19th convictions, the state has elected to defend the trial court's decision regarding suppression and reasonable and articulable suspicion and leave it at that. Without conceding anything, we have decided to accept for purposes of this appeal that the erroneous denial of the motion to suppress, if that's what this court decides, is dispositive with respect to those two convictions, and we're not challenging or litigating or accepting as correct the defendant's Fourth Amendment "you can't prosecute" claim. It's a judgment that the state has made in this case based on all the facts and circumstances presented. So we're content to leave it as the motion to suppress is dispositive with respect to those two convictions. And I think in follow-up of Justice Kahn's question, and as I understand defense counsel, the legality or illegality of anything that happened on July 19th has no legal bearing on the offenses and the issues raised with respect to July 22nd. So I want to make that clear as well. With those caveats in mind, I think it's important to kind of go through the factual record because there are bones of contention here that I think are important. The dark, unlit corner of the parking lot. That's a fair characterization based on the evidence I would submit. There's no dispute as to where in the parking lot the defendant was, and I don't think that the state, through me or Officer Santiago in his testimony, suggested that the defendant was in the outer fringes of the parking lot, far away from the building. That's not my understanding, and I don't believe that's the testimony, and that's not the point that Santiago was making. It's pretty clear where he was. Is it dark there? I think if you look at the start of the GoPro video where the defendant's setting up in his car, it's pretty dark. And contrast that with the GoPro video when the defendant reaches the mouth of the parking lot or is approaching it where Officer Santiago is coming in. That's fairly well lit. It's not exactly clear where that is in relation to the front of the library. I think you could make a fair inference, as Judge Suarez did here, that it was dark where the defendant was. Secondly, the part about quickly going to the car, that's an important point. Because in the state's view, that's a meaningful indicia of suspicion. Santiago said in pertinent part, I saw the person was quickly going to their car and pulling out of the parking lot space as I pulled in. It's the quickly going to the car part that the state is focusing on, and that's distinct from the act of driving the car. You have to remember that the event indisputably began when the defendant was outside of his car. And it began, per Santiago's testimony, which is uncontradicted, that he saw the car in the parking lot when he drove past the library on Route 81. It piqued his suspicion. He had to turn around and come back, and it's then that he enters the parking lot. There's no question that the GoPro video shows the defendant is in his car and driving slowly towards Officer Santiago, who's pulling into the parking lot. Justice McDonald?
Hang on, Mr. Segura. It'll be
sorry.
Justice Ecker first, and then Justice
okay.
McDonald. Thank you. Thank you very much.
Yes.
You're muted, Justice Ecker.
Sorry, I keep getting the microphone and my hand mixed up. I hear what you're saying. The quickly going to the car point, you know, I mean, some people don't like the police or don't like to talk to the police. So I don't know if, I mean, it's a little different from fleeing. So whether that's a reasonable and articulable suspicion, I guess, is something we may have to decide. But my question, I have two. One is, so at a visceral level, State against Edmonds is a very different case. But it's sort of from a legal perspective, because the rules that we do in this case, you know, with a white defendant in the suburbs is going to be the same as the rules we make in other situations. So how do you distinguish State against Edmonds? I guess that's question number one. I have one other question.
Well, as I recall, Edmonds, I mean, it was my case. I haven't really looked at it closely since, but he was in the darkened area of a subway parking lot, and the police, I think, pulled in. Now, this is where it gets a little confusing. My understanding of the record was the seizure didn't happen until a later point. I believe the court ruled that the seizure happened when the police drove into the lot based only on his presence in a darkened area, and somebody commanded him to stop. Again, I have a factual difference of opinion with the court, but that's, I think, what Edmonds says. So here, we're not relying just on his presence in the darkened area of the parking lot. There are a number of factors that it's after hours. I think the subway was open at Edmonds, if I recall correctly.
Yes, I believe so.
It's the only car.
The claim was he was loitering in a high crime area in the darkened part of his parking lot.
Correct. So, I mean, if you have Edmonds, to me, I think as the court has described it, and I would submit would be the worst case scenario for the state and the police, is a person loitering in a darkened parking lot of a public or semi-public place without anything else. And if that's what Edmonds stands for, that's fine, but that's definitely not this case. And the quickly going.
Can I ask one other question, Mr. Segura?
Of course, Your Honor, of course.
Or did you finish answering that one? I don't
want to cut right ahead. I'm good.
I know I can tend to cut people off, and I don't want to do that. So, right now, anyway. So on my other question is Florida against Royer, and you may have answered this. If you did, I just missed it. But you know, in that case, it's talking about how law enforcement has the right to approach people and ask them questions. And then, but the court says the person approached, however. This is assuming there is no Terry basis, right? The person approached, however, need not answer any questions put to him. Indeed, he may decline to listen to the questions at all and may go on his way. So if Mr. Haughwout was right that there wasn't a Terry basis there, he had every right in the world to drive off, didn't he? Or am I wrong? If he's right about if his assessment was right about Terry.
That's the issue that the state has elected not to pursue in this case, and I really don't feel qualified at this point to give you a formulated and informed answer on that. And I think it's a different question.
You don't contest that claim if you're not going to rely on it. You don't. I mean, either.
I'm not.
Do you disagree with that reading of Royer or not?
Would disagree that that is a general proposition that you can import into any particular factual scenario, including this one.
Why?
Because the defendant did stop and answer questions, and the detention was based on things that preceded that.
But so I'm just asking you to assume for purposes of my hypothetical, which is a developing one, so I don't blame you for not. That there was no reasonable and articulable suspicion at the time he decided to depart. At that point, would you agree that the further pursuit and so forth was didn't have a legal basis.
No, I wouldn't. I can't agree on that. And I think in Justice Dioria pointed out questions as to why that the answer to that question may be complicated. And in the state's view, this isn't the case to decide it.
How come? Isn't that the question? Maybe I'm missing the distinction you were making at the beginning, but I thought the question was whether there was a basis for a Terry stop or not.
That's correct. Yep,
so if you're wrong, you have to tell me what you want me to do. If you're wrong, we reverse on the July 19 charges. Is that right? If you're wrong?
Correct. There was an error in denying the motion to suppress, and as a result of that error, those convictions have to be reversed.
Okay, thanks.
Okay, you're very welcome, Your Honor. Again, with respect to going quickly to the car, so it's important. There are distinct events of the defendant making it from the picnic table to the car. And then there's the defendant inside the car setting up the GoPro camera. Now that raises an interesting question. Why is he setting up the camera now? It wasn't set up on the dashboard, so he wasn't using it when he got there. It is reasonable to infer that he saw the police car go by, and that he then went to the car and set the camera up and then started to drive out of the parking lot where he met Officer Santiago in the beginning. So my point is that the GoPro video doesn't cast doubt or contravene Santiago's testimony that he saw the person, the figure in the shadows, move quickly to the car. The GoPro starts inside the car. What happened before that, all we have is Santiago's testimony that he saw a person quickly moving into the car. GoPro tells us what happened after that. He sets it up. He starts to drive slowly towards the entrance. There's the police officer pulling in, turning on his lights, waving him up. So it is a fair point to say that there was a quick motion from the person who was outside the car into the car contemporaneously with the police officer driving by and or approaching.
Mr. Segura?
Yes, Your Honor.
Thank you very much. There are some questions from several justices.
Okay.
Justice McDonald, then Justice Daria, then Justice Keller.
Thank you. Well, I'm not certain I know what to make of quickly. I don't know what quickly means. I don't know if that's a full-on sprint, walking a pace. I don't know what to make of that. But let me ask you the question. Well, if this exact same scenario was at play, but the car in the parking lot was a police car, is there reasonable and articulable suspicion that a police officer's in a dark, unlit corner of a parking lot and therefore is potentially involved in criminal activity?
If Officer Santiago drove by the library and saw a Clinton police car or state trooper's car parked in the lot?
Yes.
No.
Marked or unmarked?
No, based solely on that, no. But if he saw a person quickly jump into the car, perhaps that might add. Again, I agree. It depends on the circumstances. And I'm not suggesting that the word quick conveys sprinting or flight or running. I don't think the record supports that. Plus, I think a police officer might assume that if there is reason to believe that there's another police officer at a location, especially in a marked police car, that they're on official business, and that doesn't raise any concerns or suspicions at all, except perhaps to render assistance to another police officer. I don't know. I think it would be fair to infer that the police are there for a lawful purpose, and there's no reason to go have a suspicion and go check. Not that they couldn't, but.
And at the risk of taking Justice Doria's question away from him, what if a person says, what is your reasonable and articulable suspicion to have stopped me? Does the police officer have to say anything in response?
No, the police officer is not required to say anything. Whether there's, in good judgment and haste, there's time to do it would depend on the circumstances and how important some urgency may have been to go somewhere else. Is it a wise thing to do, a courteous thing to do, an informative thing to do? Yes, I would. And that's another point that I'd like to make where there's a factual, arguable lacuna is what happened in the interchange when Santiago and the defendant were side by side. the state has added some of the other testimony to suggest that there was more said than is on the GoPro tape. And if you look at the GoPro tape, there's a couple portions where Santiago's comments are labeled as inaudible. And it certainly suggests to the state that, consistent with what he later testified, he's explaining what he wants and why he's there.
So, Counsel, let me ask you, because I want to be solicitous of others. If I understand this record correctly, Judge Suarez said that the first interaction was not a Terry stop. It was, he turned on his lights, turned them off, and waved him over just so he could engage him. And that the only salient factor between that interaction and the next stop was that he saw a gate open to the patio. What is that? What is the legal significance of that? That there's a gate open to a patio? Why does that change the dynamic of whether or not there's articulable suspicion that a criminal activity is afoot on property that's open to the public?
I believe because the officer testified that, based on his knowledge, the gate area, the patio, closed patio area, was where the prior burglary or burglars had gained access to the building. By itself, is that a sign of criminal activity?
That seems so attenuated, Counsel. I mean, that was 7 or 8 years ago. So any place that's ever experienced criminal activity is always going to be a cause of concern. I mean, that'd be pretty much the entire city of Hartford is an area of criminal concern.
No, Your Honor, that's not what the state is saying here. That is one small factor in a collection of a half a dozen or more factors that together cumulatively add up to reasonable suspicion. No, I'm not saying, nor would the state endorse the idea that high crime area, low crime area with a past incidence of criminal activity, that alone allows the police to do anything outside of the factual context in total.
Okay, thank you.
You're very welcome, Your Honor. Chief?
Thank you very much. Justice Daria.
Let me pick up there. So if I'm parsing what your position is, and I respect that you've got the decision that you've gotten from the judge and you have to take it from there. He doesn't find a reasonable articulable suspicion. The gentleman is free to go at the time he pulls up and asks some questions. He's free to go. You may or may not agree with that. Maybe you think that there's enough for Terry at that point. But that's our point of departure, is the judge makes a mixed finding of fact and law that there wasn't enough. And I hear you not to be making the argument that the fact that Mr. Haughwout took off, which may or may not have been his right, he took off. You're not relying on that to add to the Terry calculus. So you're using the gate to sort of add to the Terry calculus. And I guess the challenge we're having is, I mean, maybe if you had it straight up, Mr. Segru, to argue without unfettered by Judge Suarez's decision, you would just say that it was a reasonable articulable suspicion at the time he pulled up. But the gate seems to add so little. And so why does he get to pull him over? Nothing has really changed besides, I guess, the observation of the gate by the time he gets to the light.
No, Your Honor, I think you're misreading Judge Suarez's ruling. I understood him to say that the first encounter, the lights on off, the waving forward, was not a seizure.
Right.
That's not a ruling that the state has accepted. I don't think in good conscience that I can say that that wasn't a seizure under the state constitution, especially when Suarez testified with respect to that interaction at least 3 or 4 times that it was a motor vehicle stop. He wasn't free to leave. It was an investigative detention. I mean, it's pretty clear that I couldn't credibly stand up here and defend that. However, if I read Judge Suarez's ruling correctly, and it admittedly is not the most articulate ruling.
That may be where the confusion is. Yep, go ahead.
I think he did say there was a reasonable articulable suspicion to approach and ask questions, which is what he described that first interaction as. So I am not offering the gate to fix a initial defective stop.
Okay, so but when he
Yes, sir.
follows that paragraph, and I don't hold you to, you didn't write this, so I get it. At that time, Mr. Haughwout was not, he was certainly free to go.
Correct.
I mean, was he or wasn't he?
No, in the state's view, the overhead lights and the signal, which is effectively a command to move forward, coupled with the officer's candid testimony that that was a stop and he wasn't free to leave. Again, I know it's an objective standard, but in good conscience, I didn't think I could come up here and say that that was simply a consensual encounter at that point. The lights on and off by itself to gain attention without the waving, that's a different story. The waving without the lights, arguably a different story. But with the both of them together, I didn't feel that I could credibly say that that was not.
Okay, so let's as it relates then to the evading. How is somebody who knows that they are free to go, if they're free to go, how are they to know if it's evading or not? If he just starts to go?
He's not free to go.
Well, but he doesn't know that. He may or may not know that. Is it just an intent issue?
No, and that's another factual lacuna here, arguably. If you look at the GoPro video, as I said before, there are some unintelligible remarks attributed to Santiago. So we don't know exactly what they said, and I think it's fair to fill in those gaps with his testimony about what he later explained to the sergeant on the scene and to the defendant at other junctures as to what he was doing and why. However, the GoPro transcript in the defendant's appendix does make it very clear that Santiago did make his intentions clear. He told the defendant, put the car in park, I'll be with you in a minute. And there is a exchange attributed to Santiago and the defendant initially then, where he said he wanted to make sure that the defendant hadn't committed a crime. Well, how's he going to do that? That obviously is a reference to him going to check. And that's why he wanted the defendant to stay there.
So let me just make sure on the record. So that would be borne out, I guess, by the trial testimony, because it's not clear. You're right. I mean, Judge Suarez doesn't make a finding that he said, stay in your car, be right there. I'm going to go check this out. And you're saying that it's a reasonable inference, but does that ultimately go to the conviction or to the suppression?
Well, I mean, that's, I suppose, where the defendant puts a lot of stock in what he understood Santiago to be doing. And to the state, that has no bearing on whether Santiago possessed a reasonable and articulable suspicion or not. With respect to the defendant intending to disobey the officer's direction, I think it does have a bearing on that in a sufficiency context. And again, we have the GoPro video, we have the transcript of it that nobody disputes. And right in that initial encounter, he is quoted in the transcript as telling the defendant, I want to make sure you haven't committed a crime, which clearly implies that's why I want you to put it in park. That's why I want you to stay here. I'm going to go check. Any reasonable person in the state's view would understand that to mean stay there while I check. I'll be with you in a minute. And the defendant drives off. So no, I don't think it influences whether Santiago possessed a reasonable and articulable suspicion. Yes, it may relate to the sufficiency. Also, the waiver argument that the state made, I'm not suggesting that they waived a claim challenging the encounter from the start. What I'm saying is Mr. Schoenhorn identified 4 discrete seizures. And he said, I'm not seeking to suppress anything before the point at which the defendant told Santiago why he was there. It was from there forward that he was seeking to suppress. So from there backwards, they're not seeking suppression. And it's with all of that information that Santiago possessed, coupled with the additional information of the gate, which by itself, I agree, is not particularly significant. But in accumulation with everything, he had a reasonable and articulable suspicion at that point, certainly to stop him at the Route 81 traffic light. And that is the state's point of making the waiver argument. So, I understand it's a complicated record. You have testimony, a lot of videotapes, as I think we both agree, are fairly elucidating and probably drove a lot of the jurors' deliberations as opposed to the testimony. They certainly had the videos to compare with the testimony at various instances, as we've done here. And we're also hampered by a lack of, clear and concise factual findings and sort of a less than clear legal conclusion. So unless the court has any other questions, I'm content to rely on the state's brief for the other issues presented in this appeal. And of course, I'm always happy to answer any questions.
Thank you, Mr. Seizure. There is a question from Justice Keller.
Thank you, Chief. Good morning, Attorney Shiguru. I want to ask you a few questions about the assault on Officer Pietro.
Sure, of course.
Would you agree that if Officer Pietro hurt his back, was he one of the officers who was carrying the defendant into the room where the cell block is?
Yes,
I see,
he was.
you know, there's 3 officers, one has two, there's 2 officers, each has an arm, then there's an officer carrying his legs, okay? So I got, at some point during this struggle that starts in the, it looks like it's the entryway of the police station, the defendant seems to stop resisting and they just have to pick him up and carry him. Because at the point where they're carrying him, he doesn't appear to be really resisting. Would you agree that that would not be an assault on a peace officer? If he was hurt because he was carrying the sort of limp frame of the defendant into the cell block area?
Under these facts, yes, and I believe Officer Pietro testified and attributed his injuries to the struggle with the defendant and not to this.
To what extent was there a lot of testimony about his struggle? Were there 2 officers struggling with him at some point?
Yes, it began with Officer Verone interacting with the defendant in the lobby. They had the dispute about the camera, where to place it, whether to bring it in, not to bring it in, all of that. The defendant put it on a display case. He went to get it and take it, turned around to apparently walk out, at least in Verone's view, after being told he's under arrest, not free to leave. Verone grabs him by the arm. There's some resistance. Verone then takes him from the back and around his neck. They fall to the ground. They go basically out of the camera view. Other officers, including Pietro, join the struggle in the lobby, which is now
is the struggle in the lobby? I know I looked at it yesterday, but I was trying to remember. Is that on the camera too?
The beginning of the struggle with Verone and the defendant,
right. But the struggle where the other officers joined Verone, we can't see that, can we?
You cannot see that, Your Honor.
So did Pietro testify about that struggle?
Yes, he did.
Go
ahead.
Okay, so you believe then for sufficiency purposes, the jury might have had a reasonable basis to infer that he was hurt as a result of that struggle and not because he helped carry him to the cell block or he helped put him on the stretcher.
Correct. And again, because Verone says the defendant was struggling with Pietro, flailing an arm, kicked in his direction. Pietro said he struggled with the defendant with the others to bring him under control and eventually get him handcuffed and then carrying him into the back. But Pietro testified specifically that his injuries, he attributed them to the struggle with the defendant. And he didn't actually specify between the actual physical struggle in the lobby and carrying him into the back room, which again, that was 3 officers who did that. And I don't think the state ever proffered the carrying him into the back room as the act by which Pietro was injured.
The state alleged the struggle.
The physical struggle in the lobby, and I believe the interference was based in part on the refusing to stand up and walk and having to be carried bodily into the inner area of the police station.
All right.
Thank you, Justice Keller. There are no more questions, Mr. Seizure. Thank you very much.
Thank you, Your Honors. Have a good day.
Thank you. Attorney Bourne.
Thank you, Your Honor. Just in response to opposing counsel's mentioning of the inaudible, which is on the transcript of the recording. So there were 2 recordings from the July 19th incident. One was Mr. Haughwout's GoPro camera, the video, and another was Officer Santiago's iPhone. And he didn't turn on the iPhone right at the beginning of the encounter. So on page A126 of our appendix on the main brief is where the transcript is. And this purports to transcribe both recordings together. And so we can see when Santiago's recording is turned on. That's about minute 4:30. And at that point, there's no inaudibles in terms of Santiago because we can hear him clearly because it's his own phone. So the only inaudibles for Santiago in terms of the initial encounter with the defendant are right at the outset, right when he first approaches. It says Santiago unintelligible, Austin using the Wi-Fi. Santiago unintelligible, Austin because I was standing at the picnic table, but the bugs were eating me. And then it goes on from there. I mean, it's not reasonable to kind of speculate that Santiago said more than "What are you doing here?" And that he was explaining what he was doing. And then later he does say, you know, do you suspect me of a crime? I want to make sure you haven't committed one. Is not really the same thing as, you know, I mean, investigating whether there is any criminal conduct going on is different than having a reasonable and articulable suspicion already that there is a crime going on, and you want to confirm or dispel whether that is true. Those are two very different things. I see that there's questions.
Thank you very much, Counsel. Justice Khan.
Thank you, Chief. Counsel, my question is precisely on this issue, but the jury had the audio and visual, both the visual with audio and the cell phones as well, the audio, correct?
Yes.
And in this case, the jury could certainly go beyond. So the very transcript you point to, if you go to A129, it says Austin drives away, Austin drives silently for the remainder of the video. But I watched that video, and at the very end of that, or after he drives away, he's having a conversation with someone, and he says, change of plans. That's not in this transcript, is it?
I believe, my memory is that, the jury didn't have the transcript, but my memory is that the change of plans conversation on the phone was earlier in the encounter.
I thought it was.
I could be mistaken about that, but
I could be wrong, Counsel. But I thought he's having a conversation. The officer that blocks him drives off. The officer behind him drives off, and he starts to pull away, and he's still conversing with someone and says, "Change of plans," and that's after he drives away. So my point being that what the jury had was the actual exhibits, the actual audio and visual. And that's what they're supposed to rely on, not, and we as a court in reviewing should look to that as the primary evidence, not the transcripts that are used to assist the jury in deciphering what's on the tape, but not the actual evidence. Would you agree with that?
I agree with that, yes.
Thank you. Thank you. I yield back to the Chief.
Thank you, Justice Khan. Justice Keller.
Thank you, Chief. I was curious about a statement you made in your brief that all of the tapes and audio recordings were exhibits that the jury viewed or heard in the courtroom, but they were not with the jury during deliberations. Was the jury told that if at any time they wanted to review those, they could send out a note and come back into the courtroom or something?
Yes, I believe they were, that they could
right,
that they could view those or listen to them in the courtroom.
Okay.
Which they did not ask to rehear or rewatch anything. So is there another question? I'm sorry. And a couple of other quick points. You know, in terms of the state's argument on the Fourth Amendment issue, I would just note that that's not only relevant to the suppression issue, but also to the insufficiency, because this court has to determine, as the trial court had to determine, whether, as a matter of law, the convictions can be sustained under the Fourth Amendment. So I would just note that. And on the subject of the assault on a police officer and the proximate cause instruction, with respect to Justice Keller's questions, you know, Officer Pietro's testimony was quite vague about the injury itself and also his participation in the, he did call it a fight. You know, I engaged in the struggle. It was a full-on fight. And then the next day I was sore. But he did carry the defendant. He was one of the officers who carried him not only from the lobby to the booking area, but then also it was the officers and not the EMTs who lifted the defendant to put him on the stretcher when he was taken by ambulance to the medical facility. And there was
Counsel,
no testimony from
Justice Mullins. Sorry, Counsel. We're running short on time, so I want to make sure that he's able to ask this question. Justice Mullins?
Thank you, Chief. Good afternoon, Attorney Bourne. I'm just curious on that particular point. Sometimes it doesn't make sense to me in a sufficiency case when we look to not the evidence, but how the state argued their theory in closing. But consistent with that theme, if that's the case, if the state argued that the injury happened during the fight and never argued that it happened at any other point in time, what are we to do with that? Aren't we sort of, that's the state's theory. They're trying to prove this element by the fact that he was engaged in this fight and that's where the pain or the injury happened. And that's what they argue to the jury. Are we not limited to that? Do we kind of assume it could have happened at another point when the state didn't argue that?
I don't think the jury is limited by the state's argument. So, I mean, it's not in the charging document or in the jury instructions telling them that you may only find him guilty of interfering if he interfered at this point in the exchange. Like, the jury was never limited legally in that way. And my recollection, my recollection was not that the state was that specific in arguing the injury. You know, it was similar to Pietro, where he engaged in this encounter with the defendant, and then, and my recollection too of the state's argument in terms of the interfering was, I see my time is up. May I finish my comments?
Yes, you may. And then there'll be a question from Justice Khan.
Thank you. Was that the state was claiming that the entire incident constituted interfering, and that was articulated as well.
Okay, thank you.
Justice Khan.
You're muted, Your Honor.
You're muted. You're muted, Justice Khan.
So
That's
sorry. So sorry. You answered my question, counsel, which was about the state's theory. Usually they charge the entire incident, and that the caring, his lack of willingness, they claim, to stand up and walk in, that's part and parcel of the incident. And you answered my question, and I appreciate your you being upfront and clarifying that for us. Really appreciate that, counsel. Thank you. Thank you, Chief.
Thank you, Justice Khan. Anything final, counsel?
Just that we'd ask that the court reverse all convictions and order relief as requested for the reasons stated in the brief.
Thank you very much. And once again, I want to apologize for the delay in opening court. I try not to do that, but it was necessary, I assure you. With that, we are in recess until tomorrow morning. Thank you, counsel, for participating in this virtual platform. This is how we're getting our work done.